Item number 4. Lordship may not like to take up the matter. There is already an order of 19/4/24.
Which is that?
Item 4, my lord.
Registered to list this matter before any other bench. Go to order it was. Problems. Yes.
I beg to mention item number 17, my lord.
CME diploma.
My lord.
Yes.
Some documents, my lord, while I was going through the file, my lord, some documents I did not find. I have asked my
18
clients
matter. What do you?
only last accommodation, my lord. I have also informed my lord.
Because now your main plea was that AICT had not approved it.
My lord.
But now AICT has also given its approval for that course. In their affidavit, it is there. And you have the affidavit was filed long back. You have not filed a rejoinder. We'll see. Let the matter.
My lord.
You give me whatever documents you want over.
My lord.
May please, Lordship, item number 11, Lordship. The matter is infectious.
Mr.
N.
Ahmed, learned counsel for the petitioner, submits that the issue involved in the present writ petition has been rendered infructuous during its pendency. So accordingly, he prays that the petition be closed as having been rendered infructuous. Prayer accepted. The petition stands closed on being rendered infructuous.
Diploma. May I please,
Interim order, if any, stands vacated.
May I please, Lordship, I beg to mention item number 13. Lordship, matter has become infructuous.
Why?
Lordship, petitioner is not interested to pursue.
Then you withdraw it. It is not infructuous. You withdraw it. Mr. P. Gauhati,
Lordship.
learned counsel for the petition on instruction, submits that the petitioner desires not to press the writ petition any further. So accordingly, he prays that he be permitted to withdraw the present writ petition. Prayer accepted. Prayer accepted. Writ petition stands dismissed on withdrawal.
Lordship, I pray for listing of two matters for admission, Lordship. On Friday.
For listing of a matter, it is family pension matter listed in the part 2 list.
May I please?
Part 2 list.
May I please also? But I have to mention item number
Part 2, item number
140, family pension matter.
140. It's a matter of which year?
2023, family pension dispute
Okay.
between first wife and second wife.
May I please also? But I beg to mention item number 20, my lord. As instructed, my lord, the matter has become infructuous. 20, my lord. Matters regarding, my lord, appointment of Anganwadi worker, my lord.
Coverage area, both
Yes,
have
my
been
lord.
held
Yes.
to be not.
Yes, ma'am.
Your name?
T-Shake, my lord.
T-shirt. Same order. Purchase.
May I please?
Hello, Mr.
My lord, I beg to mention item number 21, my lord. I have to file a rejoinder, my lord.
You have circulated yesterday you.
Yes, my lord, yes.
On the prayer of Mr.
Okay,
K. Uddin, learned counsel for the petitioner. The matter stands adjourned to facilitate the petitioner to file a rejoinder. So, register to list this matter again after 4 weeks on a date to be fixed.
Lordship, I am for the respondents in this matter, Lordship. W. Rahman.
Mr.
W.
M-
Rahman
Huh?
on behalf of K. Kalita.
Mr. W. Rahman
On behalf of K. Kalita.
is present on behalf of Mr. K. Kolita, learned counsel for the correspondence.
Maybe, my lord, advance adjournment has been circulated.
Where is he gone?
My lord, he is on the station. My lord. Item 1 and 3, my lord.
1 and 3. On a prayer is made on behalf of Mr. D. R. Gugul, D.
D.
Gugul,
Gugul.
learned counsel for the petitioner for an adjournment in the matter on the ground that he is presently out of station. Prayer accepted. Registry to list those matters again after
I wait, my lord.
2 weeks on a date to be fixed.
Obliged.
Mr. K. Gugui, learned CGC, is present on behalf of the respondents. 1 and 3, huh? Yes.
For listing of a new matter, it will make
Tomorrow.
it will left out of the left over on 26, my lord. It will listed before the
Oh,
Lordship, I beg to mention an item for listing.
when?
Lordship, any date, Lordship, is a 2021 matter.
Give it. What is the issue?
Issue regarding Panchayat employees, provincialization of Panchayat employees. What has happened? There was an order, last order, there was a order to file an affidavit with a payment of 3,000 because last 4 occasions it was not
They
been filed.
filed.
They have not filed, therefore it is very difficult to list it now. Therefore, I made a mention.
Good. Next week, DDI too.
Diploma.
List item number 13.
May I please, my lord? My lord, the petitioner before your lordship is, my lord, a retired Indian Armed Force personnel, my lord, and
What is
thereafter-
the ground?
My lord,
What is your ground for challenge?
my lord, the ground for challenge is, my lord, that, my lord, the charge sheet which has been issued at page 26, my lord, is without any show cause notice. This is the first ground, my lord. No show cause notice has been issued. The department
Tell
has,
me the procedure that a show cause notice required to be preceded by, charge sheet is required to be preceded by a show cause notice. Where is the procedure?
that's a, my lord,
That's
under,
not,
my lord,
this is a departmental proceeding, bank norms are there. If you say
No.
it has been violated, kindly show me the provision which has been violated.
my lord, the departmental proceedings are, my lord, based on the annexure E, my lord, that is the bipartite settlement dated 10/4/2022. Now that deals with, my lord, the
Show
procedure.
me the exact
My
provision.
lord.
You want some time?
My lord, page 40, my lord.
Page 40. Yes.
My lord, it starts with page 39, my lord.
Hmm.
Which states, my lord, when it is decided to take any disciplinary action against an employee, such decision shall be communicated to him within 3 days thereof. The procedure in such cases shall be as follows. An employee against whom disciplinary action is proposed or likely to be taken shall be given a charge sheet clearly setting forth the circumstances appearing against
So
him.
this was done.
My lord,
This was done.
my lord.
Hmm.
And my lord, thereafter,
Hmm.
thereafter, my lord, at page 40, clause F.
40 clause F.
Yes, my lord.
Huh.
An inquiry need
This
also
is
be
also
held.
in the stage of inquiry. Nothing to do what you are submitting.
My lord.
Yes.
My lord. Now, my lord will see the charges in the charge sheet.
Fine, that is for the
Those-
inquiry officer to look into.
Now, in respect of those charges, my lord, already show cause notices were
That-
issued
There
earlier
were show cause notices
and we
issued.
replied.
We replied and
And the
now they have come
department
with a
did not,
charge
did
sheet.
not proceed it thereafter.
Mr. That is one point. Next one.
My lord, on the same allegations, my lord, the,
Naturally, that is the show cause which is now followed by a charge sheet.
my
Now,
lord.
what is the next ground?
My lord, our contention is not earlier when the show cause was made in
That is
respect
for
of
the
those
inquiry,
charges.
that is for the inquiry officer
My
to
lord.
ascertain and pass orders.
The authorities did not proceed it for any disciplinary
That
proceedings.
is
earlier.
final time when the matter is taken up. When you raise your objections, we'll come to your written statement
My
later.
lord.
Now, next ground.
My lord, next ground is, my lord, during the pendency of the proceedings, my lord, at page 132,
Hmm.
the authorities, my lord, directed the petitioner, my lord, to appear for a preliminary hearing, my lord,
Huh.
on 25/6/2000.
Then you submitted a
26, my lord.
reply.
I submitted a representation, my lord.
Representation. Now they waited for around a month. Now they have asked you to come again. What mistake? You said that only adjourn it on that day. Give me some time, I'll come. They have given you enough time.
But the authorities, my lord, in the order, my lord will see, have
Forget it.
mentioned
that
him
is that
to
is
be
immaterial.
absent.
That is immaterial. Now the date is today. Go and appear. Face the proceedings. This writ petition we are dismissing with cost.
My lord,
And yesterday when you were making a mention for
Yeah.
listing of the matter, you said that the charge sheet is not accompanied by a show cause by a list of documents?
Yes, that is also true, my lord.
Where have you
Because-
taken a plea to
my
that
lord,
effect?
It-
In your writ petition?
You know, this is a charge sheet documents, list of documents. My lord, during the pendency of the proceeding.
Where have you taken a plea to that effect in your writ petition?
My lord, paragraph 10, page 6.
Paragraph 10.
Page 6, my lord. The petitioner begs to state that the instant petition filed by the petitioner challenging the legality and validity of the impugned charge sheet. The charge sheet filed by the respondent authority without accompanying list of
Now
witnesses
show me
and
that in your written statement you have taken this plea.
in the reply, my lord, to the show cause. Page.
Your reply is at page 44. You have very elaborately answered to each of the charges. You have not said any prejudice. You understood the charges as it stood. So no prejudice has been.
Now, my lord, where is the prejudice? I will tell my lord. During the pendency, the department have supplied those documents to me by post without mentioning, my lord, in the charge sheet.
They have given you documents that they will, that's the normal procedure. Or show me
They have
that
to
there is
mention it,
a,
my lord. They have-
show me that there is a requirement in.
Otherwise, I have been prejudiced. In the reply, my
These
lord.
are issues which you can raise before the
No, my
disciplinary
lord, the
authority.
list of documents and list of witnesses were
sorry.
not supplied, my lord, along with the charge sheet.
This is not the stage for this.
Because during the pendency, my lord, by post, the department, the bank has sent it. to
Where
me.
have you said
My lord,
that?
my right has been
No,
validated.
no, where have you said that you have, there was a prejudice caused to you in filing the written statement? In the written statement, before filing of the written statement, have you approached the authorities? Give me the documents.
After the filing of the reply to the charge sheet, my lord, those documents were supplied to
So
me.
where have you taken that these documents were given to me? Where have you said in your
I have
petition?
stated it has not been supplied, my lord,
But you say it has been supplied now.
subsequently, but by the time I have replied.
Where
Now
have
today,
you
my lord,
written?
my reply is,
Mr.
my lord.
Gupta, these are your submissions. Where is the prejudice caused to the petitioner? Where is his contention raised before the authority? That because of this, I want to file a fresh written statement. Where is that plea? You have not taken, even in the letter at page 133, you have not taken anything. You said, I am not keeping well. Give me some time, I will appear. That's all. Now, when it comes to Mr. Gupta's hand, it gets to a different level. That's understood. But we were concerned with the prejudice caused to the petitioner. Nothing.
My lord will
So you appear today. It's already 10:30. Ask your petitioner to go and he'll come. Where is the inquiry being held?
No, my lord.
Nagaon. He is in Nagaon only. Go and ask him to appear. And all your pleas are kept open to be taken at the appropriate time.
My lord.
You withdraw this. We'll permit you to take all the pleas.
My lord, the list of documents, at least, my lord.
Oh, that is a plea you have not taken before the
My
disciplinary
lord, will
authority.
permit us to, my lord, take it before the preliminary, during the preliminary hearing, my lord.
Whatever you want to take, whatever legally permissible to you, you can take. But this writ petition, we are not accepting. The one I can pass an order rejecting your case with reasons. Because you have not said, that's the first thing I looked into. In your
Not
written,
have stated
see,
that,
if
my
you are
lord.
not in a position to file a reply,
My lord.
you must state that. Without prejudice to my right to file an effective reply, in absence of the documents, I am giving a reply. Fine.
No, my lord, after my reply.
And these are
documents
pleas,
are supplied.
Mr. Gupta, these are pleas which will be available to you when you make a final challenge if it happens so. Not today.
And my lord, how, sir, my lord, the charges which have been framed, my lord, these are all of 2021. When I replied, my lord, the authorities have dropped, they have not initiated any
Basically,
proceedings.
there are 4-5 issues against you. One is with regard to your documents.
My lord.
Two is with regard to the manner in which you have been working.
All replied, my lord.
That is a show
And
cause.
the
Now they are not
authorities-
satisfied. They have come with the charge sheet. You appear. We will permit you to withdraw with liberty to raise all the points which have been
My-
raised here before the authorities. Mr. H. Gupta, learned counsel for the petition, after attempting to argue the matter at some length, submits that he be permitted to withdraw the present writ petition with liberty to raise the issues raised, with liberty to urge the issues raised in the present writ petition before the inquiry officer as well as the disciplinary authority. Also, the prayer is not objected to by Mr. B.K. Sen, Learned Standing Counsel for Punjab National Bank. Also, in view of the above submission, the present writ petition stands dismissed on withdrawal with liberty as prayed for.
I'm deeply obliged. my lord.
Caveat two?
We are caveat.
Caveat has been heard. Caveat stands discharged.
Lord, I may appear on next week, my lord. Medical illness, my lord, the ground is there, my lord. Next week.
report likhi pade. Perhaps so and so. Mr.
You already sought time, my
Gupta,
lord.
Mr. Gupta has also made a prayer that as the date for appearance before the inquiry officer is fixed today, the petitioner may be permitted to appear before the inquiry officer day after, that is on 16/7/2026. Also, prayer accepted. Prayer accepted.
My lord, at 11 a.m.
At 11 a.m. Also, prayer accepted. Petitioner be permitted to appear before the inquiry officer. The inquiry officer may adjourn. The inquiry officer may accommodate the petitioner for the day and permit him to appear in the inquiry on
16th.
16/7/2026. Also, subject to the above observations, the writ petition stands dismissed on liberty with dismissed on withdrawal with liberty as prayed for.
I'm deeply obliged.
Mr. Sen, you communicate this.
I'll communicate.
And 17th onwards, if he does not appear on the next day, proceedings pertaining.
My lord. Let that observation may kindly be given, my lord, because
That is presumption.
Please,
That is presumption.
my lord.
He's not today, he'll be very happy.
I hope so, my lord. I'm deeply obliged.
Mr. Gupta, these are please receive, keep it up your sleeves.
My lord,
It will be useful when the
My
actual
lord.
time comes.
my lord. Obliged.
Obliged, my lord. Highly obliged.
Yes, madam,
Right, please, your lord.
anything?
14/5 lordship, an order was passed by Madam Jahan.
Also,
Yes,
affidavit file
affidavit
lordship,
has been
affidavit file lordship, on
Affidavit has been
21 May lordship,
Affidavit has been
file
filed.
lordship.
Yes, what do you have to say?
And Lord, this case concerns the challenge made to the order passed by the Assam Administrative Tribunal declining the plea of the petitioner. Your lordship, this petitioner was provisionally selected and appointed as constable in Assam Tea Plantation Security Force. This Assam Tea Plantation, just to give a brief overview, was raised in 1993 following an understanding between the Assam government and the Indian Tea Association, basically to provide protection to the tea garden executives of the state. The force is under the administrative control of the Director General of Police, Civil Defense and
Fine.
Home Guard.
Then you were accommodated in the Assam Special
Reserve,
Assam Industrial Security Force
yes. Lordship,
at page 20.
yes.
Okay.
On 1/11/2010, this petitioner reported for training. And then on 22/12/2012, he was discharged from training, and the reason stated therein was unauthorized absence from training from 10/11/2010. Thereafter, my lord, on 27/11/2010, a dispute arose regarding the withdrawal of money from the bank account of one Raju Bora of the same battalion.
Huh. But you were unauthorizedly absent from which date?
From 10/11/2010.
Then?
Yes, lordship. During the time of his basic training.
Your training was for 6 months.
Yes, lordship.
Now you did not complete this course.
Yes.
So how many days did you undergo training? When were you deputed for training?
Strange that this petitioner who was selected in 93. He was absorbed in 2008. And he was deputed for training on 1/11/2010.
Yes.
27/11/2010, lordship, a dispute arose regarding the withdrawal of money from the bank account of one Raju Bora of the same battalion by using his ATM card. Thereafter, on 30/11/2010, this petitioner left the place.
Hmm.
This was 3 days after the alleged incident.
Hmm.
And from 30/11/2010, he was found unauthorizedly absent from training.
Hmm.
5/12/2010, 8 days after the alleged incident, Raju Bora lodged the complaint to the Commandant 12th AP Battalion, inter alia that on 26/11/2010, the petitioner had stolen his purse containing an ATM card.
And in page 22, you have accepted that. Page
That-
22.
That is, my lord, under coercion.
Where have you said that this was under coercion? Apart from the statements in the writ petition?
Inquiry officer's direction, he had.
That was
admitted
just a
it.
preliminary inquiry to ascertain why you were absent,
Yes.
whether you were absent or not. And they found that you were absent from the training. We'll ignore the other part. But the fact that you have not completed the training and you were not there is enough for your termination in terms of your order of appointment.
Lordship, that is there, but in terms of the rules, it has to be in only when there is good and sufficient reason,
Good and sufficient reason is your absence.
Lordship, and
That is good and sufficient because you are a member of a discipline force.
Lordship.
You just vanished.
He had reasons, my lord, his
That
mother had
reason is not legal reason.
mother had expired.
That is not a projection made before the authorities by you.
Yes, Lord.
That is not a projection made. Even before the tribunal, you have not made that projection.
Yes, Lord.
This is an appeal from the tribunal.
Yes, Lord.
Tribunal's judgment is not satisfactory.
Lordship. At page
To be
59, it starts.
I know that. Somewhere they have said something about para 7, page 63. We'll ignore that because in the order also at page 25,
Yes, Lordship.
the third paragraph, not proper. But the last paragraph justifies. If we ignore the third paragraph also, this order can be saved. And how old are you now? '41, 2014, 12. 53. And you were working since 2008,
2008.
2 years.
But my lord, he had joined the services as a constable, initially appointed in 93.
That is in that Assam
Yes, lord.
T thing. That will not carry. Because here there was a screening, then the requirement was a screening of the persons in that T establishment force and a training.
Yes, lord.
Any decisions you want to say?
On how a inquiry has to be conducted, lordship, in Fulbari Tea Estate, the 3-judge bench of the Supreme Court had laid down the rules of natural justice, how it has to be followed.
This is in that industrial tribunal concept.
Lordship.
Here there is no enquiry per se with regard to any misconduct. The only thing they wanted to ascertain was whether you were absent during the enquiry. They found that you are absent during the training. Then they took this decision. How can it be said to be palpably illegal?
Lordship.
Yes.
The settled case of Narendranath Bhalla, Lordship. He has admitted that he has stolen the amount of rupees 7,000, Lordship.
Where is the show cause then?
So cause is not there, Lordship.
So cause is not there.
Huh?
So cause is not. After that, Lordship, he was unauthorized absent, Lordship, during the course of the training, Lordship.
That's the only thing.
Lordship.
But Ms. P. Chaudhary, Learned Senior Counsel, assisted by
Sinkala.
Huh?
In Sinkala.
Ms. M. Singh Khanna, Learned Counsel, Learned Legal Aid Counsel,
Yes, Lordship.
Legal Aid Counsels for the petitioner. Also heard Mr. A. Chakraborty. Chakraborty, Learned is government advocate appearing for the opponents. The petitioner in the present petition has presented a challenge to an order dated 10/9/2013 passed by the Assam Administrative Tribunal in appeal case number 1188/2012, rejecting the dismissing the same, dismissing the appeal preferred by the petitioner, said appeal preferred by the petitioner. So, the facts in brief requisite for adjudication of the issues arising in the present petition is noticed as under. Also, the petitioner hearing was initially appointed as a constable in the Assam Tea Plantation Security Force. Also, as per the policy decision arrived at in the matter by the government of Assam, Assam Special Reserve Force in the name and style of Assam Industrial Security Force was raised, and therein it was personnel in service in the erstwhile Assam Tea Plantation Security Force were given an opportunity for accommodation for absorption in the newly raised AISF. What AISF will give? So, The petitioner accordingly submitted his willingness and he, in pursuance to being screened, was found suitable for absorption in the AISF and accordingly, by an order dated 3/12/2008, the petitioner was appointed as constable in the Port Assam Special Reserve Battalion bracket 2nd Assam Industrial Security Force bracket over with effect from 15/12/2008. The said appointment was, however, subject to the condition that the petitioner would furnish an undertaking in respect of being covered by the new pension scheme, as well as his willingness to come under the Assam Special Reserve Force. The appointment was also subject to successful completion of 6 months basic training course by the petitioner. The petitioner was deputed for undergoing the training as contemplated in his order of appointment in the order dated 3/12/2008 with effect from 1/11/2010. The petitioner accordingly joined the training program, however, without any intimation and or permission, the petitioner remained unauthorizedly absent from his training with effect from 30/11/2010 till 13/12/2010. So, at the relevant point of time, a complaint was also received against the petitioner of having been involved in the theft of an amount or theft of an ATM card of a colleague constable, Raju Bora. So, the petitioner, after having remained unauthorizedly absent, had reported to the headquarters of the 2nd AISF on 18/12/2011. So, the petitioner having remained unauthorizedly absent from his training, the services of the the petitioner came to be discharged from the training by the commandant, 12th Assam Police Battalion, wide order dated 13/12/2010. Also, the said order dated 13/12/2010 having been received by the commandant, 2nd AISF Battalion, the said order dated 17/2/2011 came to be issued, terminating the services of the petitioner on account of his indisciplined conduct as well as his unauthorized absence from training course. So, the petitioner being aggrieved with the order dated 17/2/2011 preferred an appeal before the appellate authority. So, the appeal preferred by the petitioner on consideration came to be rejected by an order dated 6/1/2011 passed by the appellate authority. So, the petitioner being aggrieved by the termination effected in his case, assailed the same before the Assam Administrative Tribunal by way of instituting appeal case number 1188/2012. Also, the tribunal, upon considering the issues arising before it in the said appeal, was pleased for proceeded wide judgment dated 10/9/2013 to dismiss the said appeal. Also, being aggrieved, the petitioner has instituted the present petition. Ms. B. Chaudhary, Learned Senior Counsel, after reiterating the facts noticed herein above, has submitted that the petitioner was not afforded with an opportunity of hearing before he was terminated from his services. She submits that no show-cause notice was issued to the petitioner in the matter, and thereby the petitioner was denied an opportunity to place his stand before the respondent authorities. She further submits that there was no inquiry conducted in the matter in terms of the discipline and rules holding the field, and accordingly, the decision of the disciplinary authority of the petitioner to terminate him from his services would mandate an interference from this court. Ms. Chaudhary, by taking this court through the materials brought on record in the writ petition, has submitted that the inquiry as conducted in the matter by the authorities was only a preliminary inquiry, and the same could not have formed the basis for terminating the services of the petitioner hearing. Ms. Chaudhary next has further submitted that the petitioner petitioner was forced to remain away from his training on account of unavoidable circumstances arising in view of a false allegation being leveled against the petitioner by a colleague trainee. So she submits that it took some time for the petitioner to get the matter resolved, and accordingly had to remain away from his training program. She submits that the training program be for 26 weeks, the absence of the petitioner therefrom, with effect from 30/11/2010 to 13/12/2010, was required to be condoned by the respondent authorities, and the petitioner permitted to undergo his training if required by extending the period of such training required to be undergone by the petitioner. That would be a submission. Also, Ms. Chaudhary has further submitted that the learned tribunal, while considering the issues, had not dealt with the matter, dealt with the submissions, they dealt with the contentions raised before it on behalf of the petitioner herein, and had proceeded to hold that the petitioner, that no prejudice was caused to the petitioner on account of non-holding of a regular inquiry against him before terminating his services. Ms. Chaudhary accordingly submits that the impugned order, judgment and order dated so and so, passed by the learned tribunal, would mandate interference along with the orders dated 17/2/2011 and the order of the appellate authority dated 6/1/2012. Not much, anything left out? Mr. A. Chakraborty, learned government advocate appearing for the respondents, on the other hand, submits that per contra, submits that the petitioner admittedly had remained away from his training program without receiving permission for the same. He submits that the petitioner in the inquiry held to ascertain reasons as to why the petitioner had remained away from his training, admitted that he had remained unauthorizedly absent from the training camp with effect from 30/11/2010 to 13/12/2010. Also, Further, Mr. Chaudhary submits, Mr. Chakraborty submits that the petitioner had also admitted to the fact that he had taken away a ATM card of a colleague of his and had misutilized it by withdrawing money but had misutilized the same by withdrawing money from the bank account of the colleague of the petitioner. So, Mr. Chakraborty has submitted that the petitioner not being continuing with his training program and no permission having been granted to him to remain away from the training, the petitioner came to be discharged from the training by the commandant, 12th Assam Police Battalion, wherein the said training was being undertaken. He submits that the said petitioner having been discharged from his training program and it being a mandatory requirement, and it being a requirement in the order of appointment of the petitioner, that his such appointment would be subject to his satisfactory completion of the training program, the petitioner having not completed his training program, the discharge, the termination of the services of the petitioner, while the order dated 17/2/2011 on the said ground, would not mandate an interference from this court. Mr. Chakraborty submits that the petitioner was akin, services of the petitioner was akin to that of a probationer, and the petitioner not having satisfied the conditions set out in his order of appointment, the termination of his services would not mandate interference from this court. I think both the parties think, but it will be okay. The learned counsel for the parties at some length. Hearing concluded, judgment registered to list this matter Thursday for delivery. Thursday. It does. Nothing with
Lordship, another judgment I have passed.
This has been now decided in Chennai Metropolitan.
Yes.
Subsequently, this has been distinguished. This is to this fact only. Willful and deliberate. You have admitted your absence from the training, and the training authorities discharged you. So you won't get it. Not burdening my judgment. Because if you look into this one, subsequently, Chennai Metropolitan, I don't remember the name, Chennai Metropolitan, subsequently, recent one, 2024-25.
This has been distinguished.
This has been discussed and has been said that this is to this fact. You need not. Here the issue was that you must write that the absence was willful and deliberate. Then the Supreme Court in Chennai Metropolitan said that this is not required. This was confined to the facts of this case.
Okay.
Anyway, even if you were you did more than what a legal aid counsel could have done with the limited instructions you have. You have done more than that. That's the deal. Not interested, maybe. We'll keep it for some time, then discuss. You have not filed your affidavit in that other matter?
Sometime, my lord, because I have only this forwarded instruction, my letter to the department, my lord. Some time may be given, my lord.
We'll see. Let it come.
Yes, ma'am.
Yes.
My stand, Lordship, it is 16 OM is there, Lordship, regarding relaxation, so age relaxation.
Okay, what is that? Tell me.
Yes, Lordship, kindly take, Lord, may take up day after tomorrow, Lordship. I will apprise through an affidavit, Lordship. All the present.
Out of 7. They appointed yesterday, but only today I have a preliminary objection regarding this maintenance because 10 years, my God. After 10
Yes.
years, we were appointed in 2006. It has been selected in 2016, my God. And already we are the verge of retirement.
See, we have confined the whole thing only to that point of your being overaged.
My Lord.
And if it is if that is true, then the void ab initio, your initial thing would be void ab initio.
My Lord.
Gone. Now, if it is gone, the petitioner in this matter will only get sadistic pleasure because he will not get any monetary.
Lord.
He will not direct for his appointment.
And
So
more,
I wanted that whether, because in the in the materials which are available on record, the government authorities have also taken up this plea. But subsequently, the government has not come up with a clarification. Concrete thing. That much only I want.
My Lord. No, my Lord.
We'll see. Mr. Das, we'll have it day after. Or let us have it on Monday.
Monday.
Kindly see here in the this is a advertisement, my Lord, we have not filed any application. These are candidates are called from via my Lord. The employment exchange, my Lord.
Lordship may kindly see the illegal 13 post notified, 52 appointed. How they can,
That gone. Only we are confining ourselves to
and
that.
Lordship, out of 52, 50 have been appointed.
Have you made them
Two of us.
parties? Have you made them parties? The excess appointees, have you
I
made
have
them?
not made them parties, but Lordship, the illegal appointments, they are parties.
That's point. Illegal appointments is to the extent of they being overreached.
Over us.
Let Mr. Goswami said that there is something, let it
Yes.
bring it on record.
Yes, please.
Yes, Lordship, it's 2016.
Heard Mr. S. Das, S.K. Das, learned counsel for the petitioner. Also heard Mr. J.K. Goswami, learned legal firm senior government advocate, and Mr. P.J. Monta, assisted by Mr. I. Chaudhary, learned counsel, learned senior counsel, assisted by Mr. I. Chaudhary, learned counsel, appearing for the respond number 427. Mr. Goswami submits that an affidavit in the matter has already been prepared and would be filed on 17/7/2026. So accordingly, registry to list this matter on 22/7/2026. No further adjournment shall be granted in the matter to the state respondents to file an affidavit. We'll see it, Mr.
Lordship, 20.
17th he will file. You also will require one day to go through it.
20.
Friday, Saturday, I'm not disturbing you. Sunday.
Okay.
Monday you study. Tuesday, Wednesday you come. Why should I destroy your Friday and Saturday?
Lordship.
I'm sorry, Your Lordship, I was on like in code number 1. In item number 5, Your Lordship. Lordship, I pray this matter may be listed on next 16.
16 month.
Why?
I have tried to contact my client, Your Lordship. You have lost the contact, Your Lordship.
Why? Nothing is there. You argue on merits, whatever it's there.
Lordship, on 16, Your Lordship, today I have not.
16th, I have much matter. You argue or you withdraw. Whatever you do, you do. But we are not going to 16 matters, we are not going to it. So, yeah, 5 to go.
Day after tomorrow, Your Lordship. And then Lordship will fix it 2, Your Lordship.
2.
Okay.
The matter may be passed off for the time being.
No time being. You are appearing for?
PWD, Ardhar,
Where is Mr. Dhar?
port number 1.
Wait for something. You have got nothing to do here.
My lord, yes, and
Can you just
as per the
take it?
last order, my lord, I have wrote to them.
No, you have nothing to do. Now that that is
Yeah.
not even a statutory body, it's a private
Yes.
entity. No? Yes, how this writ petition is maintainable?
Yes, my lord.
You will have to go before you should have gone before the industrial tribunal. How is a writ maintainable?
Actually, this matter is, at the time of 2016, it was filed, that's why, my lord. Now,
Withdraw it. We are not going to entertain this. This is not maintainable.
any direction, madam. Any direction, madam.
Huh?
Any direction, madam.
I'm dismissing it. You are agreeable.
Otherwise, my lord, if he withdraw, my lord, then file a.
You have a
then,
liberty to go before the tribunal also.
then the limitation may be.
What
my
your
lord.
name?
Yes, Ahmed.
As Ahmed, learned counsel for the petitioner, after attempting to argue the matter at some length, submits that he be permitted to withdraw the present writ petition with liberty to the petitioner to approach the appropriate forum. Prayer is not objected to by Mr. K. Parasa, learned CGC, appearing for the
That's one and two.
number 1.
1 and 2, man.
1 and 2. Also, in view of the above submissions of the learned counsel for the petitioner, the present writ petition stands dismissed on withdrawal with liberty as per.
Obliged.
Final can do that.
Yes.
Well, the item 9, the one private disseminate who has made party.
Okay, no? It is on
But he has not appeared, and item 9 was not made party because in the second advertisement he was not appearing in the interview. Initially, I was both the persons were called for.
Dharmendra Boro is not a candidate. He has already been held to be not qualified.
Yes.
Oh, what is your case?
My case is I am the only candidate.
Only candidate you are there filed an affidavit said that your performance was poor. So they have cancelled it. And you have not disputed that position
No.
by way of filing a
No,
request.
no. You'll also clearly see, only I am the candidate and I have the requisite qualifications.
Fine, you have everything, but they found you to be not suitable. They have said that in many places in an affidavit. Where is your counter to that? You have not filed a counter.
But they should, in which manner, in which way I am unfit.
You
it
should
be
have
disclosed.
disputed that. You should have questioned that. You have not questioned that. Why should I go? It's not disputed.
No, I am disputing. I am disputing.
Where?
I am disputing.
They have
but-
said that in very categorical terms. And that's a very good, valid ground for cancellation of a selection process. Why not?
But it is their duty to inform me that I am not. Then I make a claim, my lord. Then I make controversy, my lord. No, nothing has been communicated to me.
Now that much water has flown
Then, my lord,
on the Saraigat bridge. Now we are not going to,
That-
16 matter, after 10 years, we are not going to revive that selection.
then, my lord, I may be allowed to file short counter, my lord.
No, sorry, 22. We are not even allowing you a day. And matter is of 2017. You
Well,
argue
well-
to your best of your ability.
Well,
Rest we will do.
item, well, so clearly see item 9.
WPC?
3013.
That's the second one.
Second. This is the because second time advertise has been issued. I appear.
That is under stay.
Yes.
We'll set aside this, ask them to issue fresh advertisement in accordance with the norms holding the field today.
As per the guidelines.
As per the guidelines.
Their
holding the
guidelines,
field
I am qualified.
today.
Yes, today I am also qualified. As per
Then
the
you,
guidelines.
if you are
Because I am
within the age limit,
I am past the BA examination, my lord.
you apply. If you are within the age limit, within everything, you apply. Who stops you?
No, my lord.
We'll provide for that.
Once I appeared, I am a qualified candidate.
I'm sorry, with
they
this,
cannot,
with this
they
stipulation, we
cannot
are not going.
they cannot deny it, my lord. And
Come to the law. That mere appearance in a selection process will entail your appointment. Show me that law. I'm passing.
Basically, their statement. They only say I am not. Why? On what
Which way? They did not deliberately discuss. In where?
The
which way I am
selection
not-
committee did not find you suitable. That's the end of the matter.
Well, it is very.
And this affidavit was filed in 22. You did not even care to file a rejoinder there.
One chance we are given.
Yeah, we are not going to give it.
Next week,
No.
file in the.
Not even hour, not even 2 o'clock. This matter is pending since 2017, last listed in 2022. No endeavor on the side of the petitioner even to get the matter listed.
No, my lord, we tried, but those matters has bundle, lots of cases are there, bundle. After mass very, then it has been separated, my lord, then
You have
listed.
not even made a mention
my
before
lord,
this court. If
Then
you
my
have
lord,
made a mention,
matter has been come in the Lozama court in several occasions, we appeared in the Lozama
if
court.
you
also.
had made a mention before this court for listing, it would have come.
But sometimes we also mention syllabus is also there, but not come because those are bundled in the 400 file something, my lord. That file. So, my lord, in several occasions, matter is listed before the thereafter in Lazima court. Asked me to furnish the address of the private respondents. But
Private respondent was a non-entity. You just brought him in.
But however, Lazima court ordered me. Lazima court, last week is a Lazima court order. Last
You know,
Lazima
made
court
him
order.
party, but in 3013 he is not a party.
Oh, my lord.
Okay, anything more?
Let consider my case because I am the only qualified candidate.
Anything more?
No, Lordship, please allow us to, for phrase advertisement, he may appear.
But Mr. J. Ahmed, learned counsel for the petition. In the above noted two petitions. Also heard Mr. J.K. Goswami, learned additional senior government advocate. No, also heard Mr. S. Dutta, learned standing counsel, Revenue and Disaster Management Department, and Mr. J.K. Goswami.
2 and 3, Lordship, Deputy District Commissioner Morigaon and Circle Officer Morigaon.
And
Circle Officer Mayam.
Goswami, learned additional senior government advocate, appearing for their respective state respondents. The matter, the petitioner in the above noted two petitions has raised a grievance with regard to the inaction on the part of the respondent authorities in proceeding to appoint in pursuance to a selection process held for appointment as Gaon Bura of page 7. 2238-2017. Huh? The petitioner in WPC number 2238-2017 has prayed for a direction upon the respondent authorities to appoint the petitioner as Gaumbura of Yarbra A to A. In pursuance to an advertisement issued for the recruitment against the set post on, when was the advertisement issued?
First, my lord.
When was the advertisement issued? On 16/2/2016. So, the petitioner in WPC number 3013/2017 has assailed an advertisement dated, a fresh advertisement dated 16/5/2017, issued by the Deputy Commissioner Morigaon for recruitment against the post of Gauhati of A uporo, A to A. Also, the issues involved in the above noted two repetitions being similar, being identical, and with the consent of the parties, the same were taken up for hearing analogously and is being disposed of by the present order. Mr. Ahmed, please have your seat.
Hello, one thing only.
Huh?
When I filed the writ petitions, I was 35 years of age.
Today you are?
Today now 17. Like 40, 44 years.
48 years.
44.
If you're not eligible, you're not eligible.
35
Minimum.
35 and 19.
Sorry.
35 and 9, my lord, 44.
Now 30 years minimum.
38.
He can apply up to 60 years.
Now you can apply up to 60 years.
That may be.
As projected by the petition, by the petitioner, in pursuance to an advertisement dated 16 to 2016 issued by the Deputy Commissioner Morigaon, inviting applications for eligible candidates for recruitment against the post of Gauhati of village, the petitioner had, along with the one Dharmendra Boro, had submitted their respective applications. Also, thereafter, the petitioner was issued with a petitioner and the said Dharmendra Boro were issued with order with a call letter requiring them to appear in an interview scheduled on 3/8/2016. So it is projected that the selection could not be, that the interview could not be held on 3/8/2016, and accordingly, the petitioner was issued with a fresh call letter on 21/2/2017, requiring him to appear in the interview scheduled on 28/2/2017. It is submitted that the petitioner had accordingly appeared in the interview held on 28/2/2017 and had performed had performed exceptionally well therein, and he was expecting that he, being the only candidate in the fray for recruitment against the post of Gauhati as advertised, while the advertisement dated 16/2/2016 would be issued with a requisite, would be issued with an order, would be favored with an order of appointment. However, it is submitted, how it is projected that the selection process held in pursuance to the advertisement dated 16/2/2016 was not taken to its logical conclusion, and apprehending that the respondent authorities may re-advertise the post in question, the petitioner had moved before this court by way of instituting repetition being WPC number 2238/2017. During the pendency of the proceedings in WPC number 2238/2017, the respondent authorities proceeded to issue a fresh advertisement. There were fresh advertisement dated 16/5/2017, inviting applications for recruitment against the post of Gauhati, which was earlier put up for recruitment via the advertisement dated 16th to 2016. Also, being aggrieved by the issuance of the fresh advertisement dated 16/5, by the 16/5/2017, the petitioner has essayed the same by way of instituting WPC number 3013/2017. Also, Mr. J. Ahmed, Learned Counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that the petitioner had the requisite qualifications which were mandated to be possessed by a candidate intending to be recruited as a recruiter for intending to be appointed as Gauhati. He submits that the respondent authorities had considered his educational qualification as well as who had examined his merit during the interview process, which was conducted by a duly appointed constituted committee, selection committee, headed by the deputy commissioner, jurisdictional deputy commissioner. Mr. Ahmed submits that the respondent authorities had, on the approaches made by the petitioner before them, to know the reasons for the delay occasioning in finalizing the process of selection involved, had never intimated the petition to the petitioner that the recruitment process as initiated by the advertisement dated 16/2/2016 was cancelled on the ground that the performance of the petitioner during the selection process was not found to be satisfactory. He submits that the said plea was taken by the respondents only in an affidavit filed in the proceedings of WPC number 3013/2017 in the year 2022, and that too without bringing on record any supporting material, supporting documents to justify such claim taken by the respondents before this court.
And also not consider the use of the Mojada view of the Mojada and circular view also not taken into consideration.
Where have you said that in the Mr. Mazumdar summons, Mr. Ahmed submits that the petitioner, being the only eligible candidate in the fray, and there being nothing adverse found against him by the respondent authorities, the candidature of the petitioner could not have been rejected by the respondent authorities on their own whims and caprices. He submits that the petitioner had performed well during the interview and there was nothing adverse coming on record in this connection against him. So accordingly, he submits that the petitioner, being the lone candidate, and he is required to be being the lone candidate in the eligible candidate in the fray, the respondent authorities could not have denied denied to the petitioner his due appointment as Gauhati in pursuance to the advertisement in question. Also, Mr.
Paragraph 69.
Paragraph of which case?
3013.
Paragraph?
One reason. Paragraph 16, my God.
Paragraph?
Paragraph 60. 3013. Because of this MLA, on his instance, I have not been.
But where is that view? That is not there.
That is not because since the financials are not taken that point of that is not taken consideration.
Mr. Ahmed has submitted that the respondent authorities had proceeded to issue the fresh advertisement dated 16/5/2017 without issuing any orders cancelling the earlier recruitment process initiated by the advertisement dated 16/2/2016. Mr. Ahmed submits that the cancellation, that the fresh advertisement was so issued basing on the pressure brought upon the respondent authorities from political circles. Mr. Amit submits that the respondent authorities succumbing to such political pressure had not declared the results of the selection process held in pursuance to the advertisement dated 16/2/2016. Accordingly, Mr. Amit submits that the impugned advertisement dated 16/5/2017 in challenge in WPC number 3013/2017 would mandate an interference from this court. So in view of the above, in the above premises, Mr. Amit submits that the respondent authorities be directed to take the process of selection initiated by the advertisement dated 16/2/2016 to its logical conclusion and issue orders of appointment to the petitioner, appointing him against the post of Gauhati as advertised by the said advertisement dated 16/2/2016. Right? Anything more? For
No, that is maybe. If I am authorized, it might as maybe condone, like transfer.
That
But it can be done, it can be done by the authority. They can.
That I will do it in my order. I'll not make yours. If I record that you are I'll dilute all your earlier submissions. I'll put it on my own.
Well,
This affidavit is filed by Mr. Dr. Mr. S. Dr. Learned Counsel for the for the Standing Counsel Revenue Department, Revenue and Disaster Management Department, as well as Mr. J.K. Goswami, Learned Additional Senior Government Advocate, appearing for the state respondents, have submitted that in pursuance to the advertisement dated 16/2/2016, a interview was scheduled on 28/2/2017, and therein only the petitioner had approached appeared in as much as he was the only eligible candidate in the fray. So, it is submitted that the performance of the petitioner in the interview process not being found to be satisfactory, the selection committee had proceeded not to declare the results of the selection process, and accordingly, the said selection process came to be abandoned. So, thereafter, the respondent authorities had issued a fresh advertisement on 16/5/2017. Also, it is submitted that the performance of the petitioner not being found up to the mark, only on account of his mere participation in the selection process, the petitioner cannot be permitted to claim that he must now be appointed irrespective of his performance as evaluated by the selection committee during the interview held in the matter. So, accordingly, it is submitted that the selection committee that the respondent authority is not taking the selection process initiated in pursuance to the advertisement dated 16/2/2016 to its logical conclusion, being based on a genuine and being based on reasonable grounds, they say would not mandate an interference from this court. Accordingly, they submit that the issuance of the fresh advertisement was on account of the necessity to fill up the post existing to fill up the post in question, and accordingly, the same was issued. So, it is further projected that the results of the selection process initiated in pursuance held in pursuance to the advertisement dated 16/2/2016, having not been declared, it cannot be contended by the petitioner that he had performed exceptionally well in the said selection process. So, accordingly, it is submitted that the fresh advertisement dated 16/5/2017 would not mandate an interference from this court, and no direction would be called upon to be issued requiring the respondent authorities to appoint the petitioner against the post of Gauhati as involved in the present reprieve. Anything more? Any idea back in yes. Dispose of.
There's an entire model that may be.
Entry model wicket. I'll put that, don't worry. At all, I will keep it. At this stage, Mr. J. Ahmed has submitted that the petitioner possesses the requisite eligibility criteria for recruitment against the post of Gauhati in terms of the eligibility criteria now currently in vogue and is also within the age limit for such recruitment. So, it is provided that in the event the petitioner satisfies the eligibility criteria mandated for recruitment to the post of Gauhati and is within the age limit prescribed for such a recruitment, in the event the respondents re-advertise issues fresh advertisement for recruitment against the post of Gauhati involved in the present writ petition, the petitioner shall also be permitted to participate in the said selection, however, subject to satisfying all requisite eligibility criteria.
Notes.
Well, let them proceed with the second advertisement. I challenge the second advertisement.
You have not applied against the second advertisement. That I'll give my reasons for that. I'm setting aside that also. I'm interfering with that second advertisement also. Yeah. Busy, man. Very busy people. So when we get them, we'll have to catch them.
I'm so sorry, my lord.
It's okay. There is this. Can't I have a banter with you?
And it's my privilege, my lord, going down before your lordship, my lord.
And what do you say?
My lord,
Supreme Court?
my lord, similar two writ petitions, three writ petitions are pending before the Honorable Court in this same matter.
Honorable Court?
Division bench, my lord. Division bench.
Division bench will take its call. I'm taking my call.
My lord, similar issue, my lord.
I will only say that they will apply before the authorities with all requisite documents. You will examine them in terms of Sukhendu Bachaji.
My lord, the matter is fixed
on the prayer of the Learned Council for the parties registered to this matter again on 29/7/20. 29th I put it, na? 29/7. I put the other matters on 29/7. I'll get more disposal. Together.
Petitioner very seriously, he's in last stage, so I am praying lordship.
Mr. Counsel,
Lordship.
you have got the
Lordship, please.
but we'll have to also give them an
Lordship,
opportunity.
lordship. I am not.
My order is ready.
Lordship, please.
Mr. Dhar,
You are supposed
this is only a bonus given to you till 29 Ms. Chakraborty yesterday. 29th, we are finishing all these matters.
Even 25th, the division bench is finishing.
And then finish. Better.
Much obliged.
Division bench has to be given the precedence. Yes. Yes. Where is your delegation?
My lord, kindly give you 1 week time, my lord. I have already talked with that concerned officer, my lord.
So,
We are-
9/6.
Yes, ma'am. We are going to file within a week, my lord, affidavit, my lord. Regarding that, 1 week, my lord, kindly 1 week, my
Your
lord.
lordship may kindly peruse the order
Yes,
dated
ma'am.
2/4/25 of this honorable court.
4/4?
Because
2/4/25.
Exactly. That is what I want them
My
to,
lord.
them to bring.
And before,
They have
after
taken
that, my lord,
to
after
25.
that, my lord, we have submitted before the court something, my lord. 1 week time, my lord. I'll file affidavit, my lord.
On the prayer of Miss A. Gain, Learned CGC, the matter stands adjourned till 23/7/2026
Yes, my lord.
to facilitate filing of an affidavit by the respondents in terms of the directions passed by this court-wide order dated 9/6/2026. It is clarified that no further adjournment shall be granted in the matter to the respondents to bring on record their stand in terms of the order dated 9/6/2026.
Master bless.
Also, Mr. M. Beria, Learned Counsel for the petitioner is present. Mr. Beria, wait for one day. That's it. When did you retire?
The petitioner retired on 31/10/18.
31/10?
18.
You are claiming promotion as commissioner and secretary.
Lordship, the
How
petitioner
many posts are there?
name recommended by the DPC laws.
How many posts are there? in the cadre?
From the SS cadre, there are 3 posts there.
3.
3 posts of commissioner secretary from the SS cadre.
And where is the roster point for this post?
This 14 point, the petitioner belongs to SC community.
SC community.
So
How
that-
many posts were filled up? How many vacancies were there when you were claimed? When your case was considered, how many vacancies were there?
And then was in the affidavit. Case 41 was my name is recommended, my name was shown in the STL number 7. Case 41.
Hmm.
Then there is a minus of the DPC lawsuit on 24/7/2018. Her name recommended, but it was here not promoted. Only she is the scheduled caste candidate along others lawsuit.
So they have taken up 7 vacancies. But the cadre strength is 3.
Lawsuit.
So show me that in cadre strength of 3, reservation is permissible. Quota is 7%.
Lawsuit.
So it will be only 0.21. Not even 1.
Yes, two lawsuit. But only my case is the
Your roster will apply when there is a quota working out. When there is no quota working out, how will the roster apply?
from 2016 lawsuit, the donor consideration is the SC candidate is from 2016. But it was held on 2018. This is the case.
Be that as it may. You retired, this selection is of 7. You
24.
retired in 10.
I am retired on 31.
Now, let us say that you are there at serial number 7. But by the time the vacancies arise, because the vacancies are of 18, 2 clear vacancies and 5 resultant vacancies.
That's it.
So by the time your turn would come, you are retired.
That is correct.
Once you have retired, Amal Satpathy would take over.
And in the motion, there is a direction that not to recommend any other person before the
Now, once you have retired, there is no question of recommendation. After you have retired, how can you claim promotion?
I claim for statutory effect from 2016 lawsuit.
Huh?
From the effect from 2016 lawsuit. Because the petitioner eligible for promotion.
You may be eligible, but the selection was held in 2018.
18.
You filed this writ petition not in 2016, you filed it in 18.
Yes, I 18. But the petitioner filed representation before the authority, but it was not considered lawsuit. That is the case.
Can't help it. Now, Amal Satpathy would take over and Supreme Court has said after retirement, there is no.
That is still lawsuit. I leave it to my lord.
Anything, Ms. Chakraborty, to add? In Angita liquidation. NJ Goswami, NJ Gogoi for the petitioner. Also heard Ms. Yeah, Amal Satpathy, I heard the judgment doesn't work. I want to say. It's also heard Mr. J.K. Goswami, additional senior government appearing for the respondent number 1, 2, 3. Also heard Mr. A. Banerjee, Learned Council appearing for the respondent number 4. And you are appearing for whom, Ms.?
I was implemented later on, my lord, in 2024 for the Social Justice Department.
Okay, for respondent number 4. And
the WPA
anybody for finance? Mr. M. Bhuya, Learned Standing Council, Finance Department for respondent number 5. You are a respondent number, Ms. Chakraborty, your respondent number? 6. And Ms. P. Chakraborty, Learned Standing Council, Department of Social Justice and Empowerment. And Empowerment, respondent number 6. Dismissed.
6.
Dismissed. I'll pass the orders.
High level.
Lordship, the item numbers 15 and 16 are similar. They are regarding fake appointments. And in item number 15, we have filed our affidavit in opposition, and item number 16, we'll be filing our affidavit in opposition within the course of the day. Lordship.
Okay. Yes, Mr. What is your case?
Your Lordship,
15.
Your Lordship, the case is that there was a inquiry already done, undertaken by the.
This petitioner was never there with the other cases.
No.
This petitioner, this is the first writ petition.
Yes, Your Lordship.
Now show me one thing, that this petitioner had received salaries when she was appointed in 2008. Where is the acquaintance roll? Where is the NPS deductions made?
Your Lordship, that I could not annex, Your Lordship.
It's not there. If you are not annexed, it is not there. You have not even produced those before. You are an NPS coverage.
Your
You
Lordship,
are having NPS coverage.
in fact, those acquaintance.
Oh, forget the acquaintance. Mr. You are a regular appointee.
Right.
2008, you are a regular appointee. As far as Ananta Gauhati is concerned, you are a regular appointee.
Right, Your Lordship.
Now that you are a regular appointee, you are under NPS.
Right, Your Lordship.
Where is your NPS number? Everything settled. One shot. Two, you were appointed by the Director of Health Services. How could you have been posted in Baska? In BTC?
Thereafter, I was transferred. That is what.
That is beyond the point. First point is, how could you have been posted in Baska? So we are dismissing this.
The only plea I have taken here is that there were first round of inquiry.
Forget the inquiry. You
I'm just
are
coming
going
to
to
that.
the meat of the matter now.
What I'm
You
trying to-
satisfy me on this.
My projected case is that, Your Lordship, there was a round of inquiry and there was a inquiry undertaken. And in the list so published, there is a list, Your Lordship. If a
Your name was not there.
not there. So
We ignore all those things. We ignore all those things. They have filed an affidavit. They have taken pleas there. We'll stick to that. Now you satisfy me.
Your Lordship, in that case, Your Lordship, I don't have all those. Admittedly, I don't have.
If you had, you would have produced it. You don't have it.
No, Your Lordship, in fact, that is something I have not asked for also, Your Lordship.
You need not ask for. That will come automatically. The appointment will be governed by the new pension rules issued by so-and-so. So-and-so, so-and-so, so-and-so. The appointee should join his place of posting and so-and-so. Appointment will stand consent. So 2008, you have to be a member of the
NPS. Right.
Then 2013, you are automatic, you are transferred from Baska. What jurisdiction does Dhruvo Hojai has to appoint you in Baska?
Right, Your Lordship.
That's the end of the matter.
Your Lordship, my only plea at this stage is, Your Lordship, let them conduct a proper inquiry and there
You are working.
Yes, Your Lordship. I'm
Till
working.
date.
Yes, Your Lordship, I'm working.
That's the end of the matter.
So
We are
let-
dismissing this.
Your Lordship will only, no, Your Lordship, it is not a case that the health department.
You show me that you are there.
What I am paying
No,
for,
no,
Your Lordship, at this stage.
Mr. This is a 226 code. We'll have to look into both aspects.
Right, Your
We
Lordship.
are not going into technicalities. You show me you had a PRAN number in 2008.
No, I have not annexed it. That's what I'm saying.
Finished.
But what I'm trying, yes, Your Lordship, I'll leave it to that. But what I'm trying to, what my prayer is that before they proceed, Your Lordship, that is their project with case.
Whence this appointment is fake. 311 goes out of the.
Fine, that is their allegations.
You satisfy me.
Now the question is that when they come up with the plea that this appointment is fake or forged, whatever they come up and say, let them follow a process which has been done in other cases also, Your Lordship. Let them go by that. I have nothing to say in that case.
No process is required.
Your Lordship, in other series of cases, if Your Lordship remembers, a process was being followed.
Oh, I have forgotten all that there only.
No, I'm not saying that. What I'm trying to
I've
say.
forgotten those there.
No. What I'm trying to say is that a process is there. Your Lordship, this is all about procedural, Your Lordship. Let them follow-
Procedure in case wherein you have established that there is some semblance of authority behind those appointments. Yes, we understand. But here it's a clear case. And see, this affidavit in opposition was filed on 25/6/25.
Yes, your lordship.
And you have not filed a reply to
Yes,
this,
your lordship.
rejoinder to this. And I know. it will
No,
be
no,
difficult
the
for you.
rejoinder I could not file because I could not contact these persons. Now I contacted. The other rejoinder has not been filed, which is in the other case. Your lordship.
Where is is there an interim order operating? Here?
Yes, your lordship.
But it was not extended, Lordship.
No, it was that.
Is he working?
Lordship, I'm
Yes,
not
your
aware of
lordship.
that. Lordship.
Get that information whether he is working.
But it-
2 o'clock.
Your lordship, 3110. Lordship, I'm working. I'm making a statement. I'm working.
You don't have contact with your
No,
client.
I have contacted your lordship.
You say you don't have contact with your
I didn't
client.
have contact at that point of time. Later on, I could contact. Your lordship has not allowed me to complete the
Hmm.
sentence. Your lordship will see the order dated 31/10/2018. There is an order which says that similar order is passed in case as far as the petitioner is concerned, directing the authorities not to pass any adverse order without the leave of this court, your lordship. So this
This
process
is a continuing order.
this is a continuing order, and
So
therefore,
will. Oh, list this matter before any other bench report me, both of them. I've already passed an order earlier. 15, 16. There is already an order. So, Mr. Rana,
I'm sorry, I did not go through that. I'm sorry.
Much obliged, Lordship.
এইবোৰ চাব মই এইটো লিখি দিম তাতে ইয়াত আছে আৰু ৰবা দিয়ে এইটো বাই নট বাই ইয়াত লিখি দিব লাগে এনেই চাই আহোঁ ফাইলটো তাত এইটো
For all kind of technical extensions, approval of the AICT is required. In this case,
AICT approval has come now.
now it has come in the
Did
year
it as it went?
2013.
And where are, if we have to accept your plea, others will be affected. Where are they? The persons who would be affected.
No, I am not saying that.
Because if I create a different channel for you, they will be affected, right or wrongly. Their channel
I
will
am
get blocked.
paying for only for preparing a separate gradation list.
That's what I'm saying. Once I prepare a separate gradation list, you will get a advanced thing because you are now more qualified. These people who are now equivalent will suffer. They are not before you, before this court. They are not before this court. Then. And the AICT thing is already taken care of.
Well, they have in their affidavit, though they have submitted the website, the screenshot of the
You have not filed a rejoinder to that affidavit. Why take all this?
Even during it is.
And now you have blocked the mighty Union of India also from appearing before this court. See?
I informed Mr. Akedi Chaudhary that I'll pay for.
Akedi Chaudhary is a busy person.
I'll pay for adjournment, my lord.
Anything more?
Question.
Anything more? Third day, Learning Council for the parties at some length. Hearing remains inconclusive. Raised it to list this matter again on Monday. I'll pass the order.
Monday, my lord, he'll not be
You
available.
did not be there. I'll pass the orders.
My lord.
Only I'm scheduling the passing of the order.
My lord, Akedi has stated that he will be not available for 2 weeks.
No need. We have heard him today only.
My lord. Obliged, my lord.
Akedi Chaudhary namtu ta report likhi to live. Yes, Mr. Talukdar. What is your stand here? Government stand?
My lord, the order passed by the registrar, page 66, my lord. So, my lord, this is an order saying that, my lord, that there are evidence of misappropriation, my lord. So, my lord, he has been debarred.
What is the basis? Where are the records? No records. Records will not be there.
2018 matter, my lord.
And you are continuing as on.
My lord, it stays there, but functioning is not continuing, my lord.
not
As
50.
because given the petition.
Mr. Sigdar has kept you out in spite of our orders. Mr. Sigdar, he is continuing or not?
Not continuing so far mine.
And what is there now?
As because forcefully, my lord, obstructed to enter into the.
No, have you filed a contempt?
That is not, my lord.
Then?
Recently, my lord, I have been engaged in this case, my lord. Earlier counsel is sensed.
Oh. Okay, make your submissions.
My lord, some accommodation, my lord, in some time, my lord.
Why? 18 matter.
My lord,
Only time you withdraw this and go, I'll give you time. Otherwise, I'm not giving. Nothing is you.
as because, my lord,
The
something
order, I'm not very satisfied, but given the conduct otherwise coming on record, their affidavits, you are not in the interest of the society.
my lord, place the matter, my lord.
On the prayer of Mr. K.U. Ahmed, learned counsel for the petitioner, registry to list this matter again on 23/7/2026 to facilitate him to prepare the matter. Prepare the matter. First of all, prepare the matter and make his submissions.
My lord,
No further adjournment shall be granted.
4th of August, my lord.
No, 23. No further adjournment shall be granted in the matter. You're not in Assam, Gauhati on 23rd.
My lord.
Then come down. I'll forget otherwise.
Similar case.
Registry to, as agreed to by the learned counsel for the parties, registry to list this matter on 29/7/2020.
Obliged, Lord.
Fix the other matters on.
Lord.
Mr. Deka,
Lord.
when you had approached this court on the last occasion,
Lord.
this was not recognized. The higher secondary section was not recognized by the government, nor by the SEBA.
Initially in 2022,
Ah.
by July 2022, that has been not recognized.
Recognized, they give you a
Later on cancel.
cancel.
Yes.
Be that as it may. So in that context, when you were a private entity, you were a private entity.
Lordship.
Although you were sponsored by a provincialized school, you were a private entity. Now that private entity had to have a recognition, a permission from the government for admitting students.
Lordship.
Accordingly, this court in the last round of litigation, you were also involved.
Yes.
Said that no, consider for giving a recognition, permission, and then if done, the Darpan portal will be opened and you can
Ultimately
do it.
considered.
Now tell me, a provincialized school, is it required to register itself in Darpan?
Yes, Lordship.
Huh?
Because initially that was the high school, provincial as
No,
high school.
I'm not on that. Is forget your these schools, normal school. Is a provincialized high school, higher secondary school required to register themselves in Darpan?
Yes, Lordship.
Where is that?
No, it is from their notification.
required?
Yes, my
The
lord,
notification is there.
kindly see page 255
There's a
of the
notification.
affidavit filed by the government, my lord.
Yes, and
255.
yes, this is the
My lord,
criteria. That's a
norms
kind
and procedure for according provisional registration affiliation institution code
And a
regarding A, my lord, government provincialized institution, established institution upgraded by the Government of
Yes.
Assam has to apply by filling up.
So ultimately, they have upgraded. Upgradation order is there. Now,
Now, who are you? You are not recognized. The upgradation says that it will be managed by the postgraduate qualified teachers in the high school.
So the initial proposal submitted by the provincialized high school, that has been recognized. And ultimately,
The upgradation order does not recognize you.
That upgradation itself says, Lordship, itself mean that they have recognized. That is why they have
No.
upgraded.
If
Because
you come to
now
the
what is the
upgrade- you
requirement?
You come to the upgradation order.
Lordship, for that, I am coming, Lordship, in page 255, what is the requirement? Lordship,
I'll
kindly say.
come to 255, come to your right first.
Order, provincialization order.
Not provincialization order.
Sorry,
the upgradation.
recognition. Yes, 230. 230, no. 229. 229.
227.
227, our name is at serial number.
You forget that, come to the conditions.
Yes,
Are upgraded as to higher secondary schools,
yes,
subject to fulfillment of following criteria condition.
yes.
Uh,
There should not be any amalgamation proposal.
no, the school must have minimum 4 graduate teachers having postgraduate degree in minimum 4 courses.
Lordship.
No new post shall be created for the purpose. The school must give undertaking that they will run the higher secondary classes with existing qualified faculty
Yes,
having postgraduate.
Lordship.
So you are not there. You are not of high school.
No, we are in the higher secondary
You
section.
were appointed by the managing committee in the higher secondary.
Yes,
Now, while upgrading that school, your existence is not recognized by the government. It says that the high school teachers,
that filling of the post or the payment of salary, that will come, Lordship, after having the,
that because one of your prayers is for your accommodation.
no. This is still, Lordship, the open portal is open. Our
I'm
service
sorry,
shall,
Mr.
our service shall
Come-
not be
come to your
disturbed.
prayer. Adjust the services of the petitioner in the upgraded higher secondary sections.
So amongst others, the main prayer is, Lordship, prayer number 2 and
So that if that prayer is now required to be made, that will be made by by the managing committee, not by you. We can't recognize you now.
I'm harping on para 2 and 3 and 4, the open portal, because the admitted fact is that
Mr. Counsel, if that is a grievance, now that this school has been recognized, brought within the fold of a provincialized school,
Lordship,
it is now a provincialized school.
not provincialized. The
Upgraded,
higher secondary section is not provincialized.
it is upgraded to higher secondary
No,
schools.
that means it is
So
not, it
if
is yet
that
to be
is there,
provincialized.
if that is so, let the managing committee come if they have any grievance. Who are you?
We are the part of the school, or the higher secondary section.
You are not recognized now. Yes,
Lordship, here, Lordship, we are not asking for any salary or any provincialization.
you are asking for that.
No.
Yes, you are
Prayer,
asking
prayer
for that.
number 3, Lordship.
You know, how can I reach 3 without going through 1 and 2?
No, that, Lordship, I will
My lord,
stop that prayer,
uh,
Lordship.
yeah,
Prayer number 3.
3 schools are there, my lord, and amongst 3 schools, my lord, 2 schools has already affiliated by the board, having
Yeah.
school code.
Mhm.
Only 1 school has not
Not there.
affiliated.
The Sabha moment they give a code, particular school code. Now it is the requirement after upgradation, it is the duty of the.
Who are you? I'm asking you, who are you?
Lordship,
You are-
where
you're
are
not-
the-
you're-
where
you're
the-
not- You're
where-
not the person agreed.
We are the teaching
It has
staff
to
of
be
the,
the managing committee of the school.
we are the teaching staff of the, that upgradation high school.
Staff, Mr. Counsel, after the order at page 227, you are not recognized. What is your status?
That is not required. We are concerned with the institutions. Now,
Tomorrow, anybody will walk in and ask for a writ of mandamus, we'll pass it. If there is a grievance, let the managing committee come. Let the managing committee come. Managing committee is not before us.
Ultimately, the school is concerned about the students.
I know.
They have that,
I know.
that
I
trend,
know.
that trend is.
I know, and that the government has taken care of that.
No, yes, taken care of that. That is why they have upgraded the schools.
And said it will be run by the high school teachers who have postgraduate.
That is so far the postgraduate teacher working in the provincialized high schools. But this order does not, lordship, say anything about the existing postgraduate teacher.
It does not
Yeah,
say because it
because
did not say.
The reason is.
Come to clause 6 at page 227.
No financial grant. Yes, but the lordship prior to that, kindly see their guideline of upgradation. What
You
are the
tell me
conditions?
about your locus first.
My locus is also where the serving teachers.
You are
of
not the serving teachers.
In the
You are not recognized after the upgradation. You have not made a challenge to this order.
that recognition.
You have not made a challenge to this order at page 227.
Not required because we're concerned with only the Darpan portal.
We'll hold that. We'll say that you are
Now,
not.
lordship, kindly see the page 249.
Registration has been going on for all the upgraded
Yes,
schools, your
because
lordship. Under the
we
Dorpan
have to
portal,
now.
the students have been registered, your lordship.
Now-
That is
Even
why-
in there, they are also permitted.
Yes.
Their
No,
names
the
are-
Darpan portal is only for the students, your lordship, for registration of for
Is
taking
this
admission.
schools there?
Yes, sir, because they have been upgraded. I had a talk with one, IS,
Okay.
with the Biswanath of, IS of, Inspector of Schools, your lordship.
Hmm.
And their school is Bapuji High School.
Yes.
For Biswanath. So they had inquired from the principal of that school, your lordship, and they have stated that the registrations have been going on since last
You get
last
that
year.
thing in writing.
No, in writing. your lordship.
Lordship,
I have
They have to-
requested them,
Lordship.
they might give me today or maybe.
Today, on the prayer of Ms. D. Musahari, Learned Council for the Learned Standing Council, Secondary Division Department, registry to list this matter again. 20 will do
Lordship, lordship.
on 27/2026,
I'll-
on which date she shall
Let me see.
receive instructions in writing from the competent authority as to whether the school of the petitioners in the present writ petition have also been included in the Darpan portal and have been opened for the selected by students desirous for enrollment in higher secondary sections.
Lordship, the answer is page 255.
Let us see if the principal is saying, that is why I'm telling you, you have no locus, you are somebody
No,
else,
the
you are
only-
outsider.
Lordship,
No.
because I have stated in my affidavit in
Madam, you
opposition-
get it in writing the current position.
Lordship, in 237, we have stated that so far as the registration of upgraded high secondary schools through Darpan portal for the purpose of admission of students are concerned, it is stated that the same are governed as per notification of, notification dated.
I don't want that.
2026.
I don't want
Lord-
what is there in the law. I
Lordship.
want what is happening practically.
Practically, your lordship.
Give me in writing that.
Lordship, lordship. I'll try to get for the other schools.
give
other
me in
two
writing.
schools.
Then I will throw out Mr. Deka.
Lordship.
Not the repetition, throw out Mr. Deka.
Yes, October.
Now only because we have to pay the 15,000 fees.
Take it as, no.
Once the school is upgraded, that my learned friend said that notification of 5/4/2025. Once the school is upgraded, the requirement is there is a website of this
Mr.
Sabha.
Deka, I'm finding it difficult to recognize you. That's the problem. We'll see. Let them get that. You want only Darpan.
Yes.
Lordship.
Lalit.
This review file, the state, my lord.
The decision that this court had relied on,
My lord.
that is the case of Vikas Sankhala.
Yes, my lord.
That issue does not require any interference.
My lord.
Now, they have taken a plea
Yes.
that you had taken a relaxation of your age.
That's true.
And that will now debar you from being migrated to
Yes, my lord.
this thing.
I
Madam,
placed
you
the
are-
judgment
you
with
are- you are appearing?
Lordship.
Where is the stipulation that a person who has taken what do you call that?
Relaxation, your lordship.
A relaxation of age is not entitled to be migrated to a,
Lordship, that was the only ground that we had.
where is that provision?
Lordship, but now it has been settled by the Supreme Court, your lordship, in Chaya.
Yes.
In Chaya and others, your lordship, it has been already settled, where it has been stated that relaxation in qualifying criteria only affects the eligibility and not merit, your lordship.
That's the position, but
Lordship.
you can do it.
Only if the rule, my lord, puts an
If the
embargo.
rule or
There is no embargo, my lord.
Jitendra Kumar Singh is on a particular rule.
Yes.
Yes, your lordship.
And Sajib Roy, yes.
Chaya has clarified it further, my lord.
So Sajib Roy
Yes,
and now
sir.
Chaya has
Chaya.
clarified
Yes,
it. So what is there now? Nothing.
Nothing.
We'll not go anywhere. We'll say that in terms of
Lordship.
the decision of these two courts,
Lordship.
you are not pressing the review,
Lordship.
right?
Lordship.
Now when are you complying with the order?
Lordship,
The present review petition heard Ms. D. Musahari, learned counsel for the petitioner, review petitioners, and Mr. M. Dr. learned senior counsel appearing, assisted by Huh? L. Deca, learned counsel for the respondent. Only one
1
year.
respondent. The present review petition has been instituted, praying for a review of the order dated.
Lordship, it is.
The judgment and order dated 10/6/2024 passed by this court in WPC number 2601/2023. Also, the review petitioners have sought for review of the said judgment on the ground that the petitioner, that the respondent herein had appeared in the selection process in question after availing the relaxation of age by relaxation of age as available for candidates belonging to the scheduled caste community. Accordingly, it is projected in the review petition that the petitioner, having taken a relaxation for appearing in the selection process, she would not be entitled to have her case considered against a vacancy other than the vacancy reserved for scheduled caste communities. In other words, the petitioner, it would not be permissible to permit it would not be possible to migrate the petitioner to unreserved posts which have remained unfilled. However, today when the matter was taken up, Ms. D. Mushahari fairly has submitted that in terms of the recent decisions of the Honorable Supreme Court in the case of
Chaya and others.
Sajib also,
Yes, ma'am. Sajib.
in the case of Union of India versus Sajib Roy, SAJIB, Sajib Roy, reported in 2025 SCC Online SC 1943 and Chaya and others versus State of Maharashtra and another, reported in 2026 SCC Online SC 457. The issue, the contention raised by the review petitioners in the present review petitioner would not be maintainable. So she submits that in terms of the said decisions of the Honorable Supreme Court, there being no specific provision in the rules preventing such migration of candidates candidates appearing in a selection process after availing the relaxation for reserve community candidates, the directions passed by this court for considering the case of the petitioner against the unreserved vacant post would not mandate to be reviewed. Is not erroneous and accordingly would not mandate and review. Mr. Dr. Learned Senior Counsel appearing for the respondent also submits that the decisions of the Honorable Supreme Court referred to by the Learned Counsel for the review petitioner has settled the position and the order review of and there is no error in the order dated so and so. Order dated 10 judgment and order dated so and so, 10/6/20, WPC number so and so, mandating a review of the same, mandating for a review of the same. Accordingly, he submits that the review petition would mandate to be dismissed. In view of the submissions made by the learned counsel for the parties as well as more particularly the submissions made by the learned counsel for the review petitioner, this court is of the considered view that in view of the settled position of law coming into being in terms of the decisions of the Honorable Supreme Court in the case of Sajib Roy and Chaya Hetu, Supra, the order that no error is found to exist in the order, judgment and order dated so and so, 10/6/2024 passed by this court in WBC number 2601/2023, and accordingly, the present review petition stands dismissed.
So if the respondents have passed an order, my lord, that is at page 103, my lord, rejecting my consideration.
There is speaking.
That is speaking, that is.
No, that will go now.
That is gone. That is to go.
We are not entertaining the and contempt. Ms. Musahari, learned counsel for the respondent, submits that in view of the dismissal of the review petition, the respondent shall process the matter and proceed to comply with the directions passed by this court by judgment and order dated 10/6/2024 in WPC number 2601/2023, and accordingly prays that she be granted time till 27/7/2026 to place on record the compliance report. Registry to list this matter on 20.
Small bracket, Mr. Khatunia names me, because in the contempt case, I have, my name is not there, your lordship. I have not.
You get Mr. Khatonia.
So he is, today he is not available, your lordship. Because in the
Contempt to Khatonia. As prayed for by the learned counsel for the parties, registry to list this matter again. Put out right here. 17th he is here. 17th.
Diplomat, by the lordship.
Review to dismiss.
May I please?
Yes, where is your instructions?
Yes, lordship. So before placing the instruction, lordship, this writ petition has been instituted, lordship, by making some false and misleading statement,
So
lordship.
that we will see when it comes.
Yes,
But where is your instruction? 4/6/26.
Second place. Second page, lordship.
Have you given him a copy? Mr. Das, you go through this once. We'll have it on Thursday. Go through it. Thursday, Tuesday.
Next Tuesday.
Mr. K. Kolita in learned counsel for the respondents has placed on record the instructions received by him in terms of the queries raised by this court on 4/6/2026. A copy of the said instructions is also furnished to Mr. S. Das, learned counsel for the petition. To facilitate Mr. Das to peruse the same, registry to list this matter, the matter stands adjourned today. Registry to list this matter on 21/7/2026 for further hearing.
Hello.
It will tie up with her. A copy of the instructions furnished by Mr. K. Kolita is kept on record and marked as X for reference. X marigine.
My lord has already heard this matter.
Forgot.
But I have given one written submission. Perhaps it's there, my lord. This will assist your lordship, my lord. Is it there in the records?
Second.
If not, my lord, I have an extra copy.
No, wait.
To read, you I have given an extra copy.
You had given it during the last hearing, I suppose.
Yes, my lord. I just handed over it It's there, I have given an extra copy.
Moi nasiguro. Tao siya lagi yun sir. Order na yun. But the Learning Council for the parties at some length, at length, hearing concluded, registered to discuss at a date dia 3 তারিখ or agot. 31 to agot dia 29 monat dia. 29.
Fine.
29 monat dia. 29 so 31 for delivery of orders.
DPO.
Okay.
এইখিনি আছে না দুটা আছে বাকি আছে মাতা দুটা বজাত কৰিম একটু না কেন বাবুরে এইটো লাগি থাকিব ৰেগুলাৰাইজেশ্যন আমাৰ নতুন যেটো সুপ্ৰিম কোৰ্টৰ অৰ্ডাৰ আছে আমি এটা অৰ্ডাৰ পাছ কৰিছিলো আপলোড হৈছে এইটো ৰাখি দিলে সেই সুপ্ৰিমটো বাচ্চা আছে ষ্টত আছে এইটো আহিলে লেপটপ You've got the instructions.
The last phase in the compilation is the list, my lord, which was received from the headmaster.
Oh.
Headmaster showed himself as social science. And respond number 7, who is shown as the Hindi teacher, she is senior to the petitioner.
There was a list here. Where is that list?
That list, page 25.
That is the particular. But why this is shown as English?
Hello?
Here it is shown as English.
Yes, here it is shown as English.
So you, why this? From where have you got this list, Mr. Das?
My lord, that has been issued by the my lord, headmaster himself, my lord. And the petitioner has provided it to me. And my lord, I would like to draw your lordship's kind, my lord, attention as we get.
Same day, 2 list. Why?
That the headmaster and the
Is he a
petitioner
party
can-
here? Headmaster is the
Headmaster is
party.
the party.
R6, you are appearing.
Yeah.
Mr. P. Mohanto is appearing.
Oh.
My lord, in the dice that
They have not filed any affidavit here.
they have not filed any affidavits. My lord, on page number 30, just for a moment, my lord, that is the dice data, my lord. So far, my limited knowledge is concerned, my lord, it is difficult to manipulate the dice. But in the dice data, my lord, on page 35.
30?
35 more. That my lord, all the my lord, the subject thoughts are they are in my on the
Language.
Yes, my lord. Joymoti sir on the extreme right, my lord. His
Language.
the petitioner. His subject appointed,
He is still in service, this.
social study here.
Sujya Kumar Sara is still in service.
No, my lord, after the 2000, our service was not provincialized.
No, this principal.
My lord.
Headmaster is in service.
Yes, my lord, he is in service. He is in service as on date. Here, my lord, as per the record, as per the dice data, my lord, the petitioner is.
Let Mr. Munta come, we'll
Yes,
see.
and this dice data is also of 2019-20, Milord.
Be that
And
as it may.
it's a U dice, whereas Milord, under the statute, Milord, it is the NUPA dice which is seen, Milord.
Be that as it may,
So
here
because-
there is, he says his language.
Because,
These are on the
Milord,
same data.
Yes.
Can't say, Milord, because specifically the statute provided NUPA dice. Since NUPA dice, there is no scope of rectification or modification, Milord. U dice can be done at the CRC level, and NUPA dice only in the
So
year.
where's that NUPA dice?
That, Milord, the SSA can provide.
You had considered it, you have it.
Well, we have this recommendation from the principal, the headmaster, sorry.
But the recommendation from the headmaster, seems that there are two recommendations.
Yes.
But that one which is annexed with the writ petition, well, I cannot say about that. But during the process of provincialization, this is the recommendation which is received by us. And the district scrutiny committee proceeded based on this recommendation. Here, my lord, there is a change in respect of Niranjan Pegu has been shown as English in that, and petitioner is shown as Assamese. However, in the one which is annexed to the writ petition,
Who is shown as English?
Niranjan Pegu, who also happens to be senior to the petitioner, and and the petitioner is shown as
Petitioner is Joymati Sora.
Sora.
Who have been provincialized here now?
My lord, Surya Kumar Sora, my lord, and Kanakanto Pegu, and Bobita Dole.
Bobita Dole, Hindi.
Bobita Dole. My lord, Bobita Dole is my lord senior to the my lord Niranjan Pegu.
Bobita Dole is not there in the dice data you have produced.
Yes, my
right?
Yes, my Bobita Dole is not there. His language, my lord, Hindi.
Kanan Devi has not been provincialized.
Hello?
Kanan Devi Pegu?
Kanan Devi Pegu is provincial.
Provincialized. She is mathematics.
How many were prof? Three were provincial.
Three were provincialized.
So you can have a grievance against Sujya Kumar Sora and Bobita Dole.
And Bobita.
Right? So there is no change in Bobita Dole. There is no change in Kanan Pegu. Change is only with regard to the headmaster.
Surya Kumar Sora.
Surya Kumar Sharma and the petition.
And the petition.
Here she is shown, she cannot be here. This data is also wrong. Here you are shown as social science.
Yes, my lord.
But you are a language teacher.
In the
dice.
No, dice, my lord, I am social science.
No, main subject taught language.
No, my lord, the main subject taught my lord social studies. Appointed for the subject social studies.
Okay.
And thereafter main subject taught is my lord social studies.
Let Mr. Mohanta come. Just call him.
Mohanta go.
We'll take it up after some time.
Bye.
Bye. Where is the petitioner?
My lord, my junior is going to call him.
We will take
This
it up.
is the my lord.
Let him come. We'll hear it in his.
Yes, my lord.
Facts are, I've been dictating it, but the facts will take some time. Due to paucity of time today, the order could not be delivered. As the hearing is already concluded, the matter stands reserved for, a case stands reserved for judgment. See, next to him.
Much obliged, Lordship.
Mr. Bothakur was here. To dispose the head to who you say to dispose. Dispose of. CAV. I have been dictating, but I could not complete. I've made it CAV.
Point out 2 points, my lord.
Again, I've dictated half the order.
Yes, only the Lordship may kindly, the advertisement page 98, all the posts are reserved for backlog. There's in our affidavit, we have annex. And the other point Lordship has raised, like we are trying to mislead this honorable court, because in the paragraph number 5, we have stated in the affidavit, we have stated that we have cancelled all the 20 number of posts in the year 2022. In the additional affidavit, point number 6, this Lordship has pointed out. And in the paragraph number 5, Lordship, the above paragraph, we have stated the same thing, that we have cancelled page 127, that my lord has pointed out. Page 127, Lordship. Paragraph number 5, my lord. May I read, my lord? That the deponent beg to submit that as the appointment number 25 number post of last was marked as backlog, the appointment order was kept in abeyance by order dated 19/1/2010 and thereafter cancelled by order dated 25/2022. This is the annexer 7 and 8 of the affidavit in opposition that we have already filed. Then paragraph number 6, my lord, that the deponent beg to submit that out of 25 number posts, 22 numbers of appointment in the cadre law school which were cancelled, the date was missing. So lordship was the impression that we are trying to mislead this honorable court, that which were cancelled on 25/2022. Only the date is missing there. Because in paragraph 5, we have stated the above paragraph, and in our affidavit in opposition, we have annexed the cancellation order.
When was the appointment order issued?
It was issued in the year 2010, lordship. 2009.
But they continued for a year.
2019/1/2010, we had kept in abeyance. They are not continuing. They did not join even.
No. We continued, my lord.
No, lordship. 19/1/2010.
That order, my lord, no order was passed, reverting us back to the post of master worker, my lord.
No, lordship.
No order was
19/1/2010, it was kept in abeyance.
When was the order issued?
Order was issued.
2009.
Yes.
But the month was 2 months before, lordship. I am showing 2009. Call letter was
23/12/2009.
And in 19/1/2010, we have issued the kept in abeyance order. Only few days. And he have, in the entire service period, he has worked as a master worker. We have annexed in our affidavit the master worker payment sheet, lordship. And after his retirement, he came before this honorable court for his regulation.
When was your first appointment?
1/1/1994.
1/1/1994.
The Sukhenda is not applicable in this matter also. Sukhenda Bhattacharya.
But my case is that, my lord, after my regularization in the year 2009, my lord, they have
Regularization means your
Regular
appointment.
Regular appointment. My lord, they have kept in abeyance the order by which my service was, I was regularly appointed. But I was allowed to continue in the service.
But you were not paid the salaries of them.
Yes, my lord. But
so what made you wait till 2022 to
my lord,
process?
that there is some delay. That is admitted, my lord. There is some delay. But my lord, it doesn't mean, my lord, I will lose everything, my lord. My lord, the lordship is aware that, my lord, in case of, my lord, payment of salary and pension, my lord,
3 years.
because my lord, third party is not affected in this case, my lord.
My lordship, he is a unreserved category person. He is not reserved category. All the posts are reserved for backlog vacancies.
My lord, she has mentioned that, my lord, they have cancelled my appointment in the year 2022. That is after my retirement. That also, my lord, was on the last occasion, lordship raised a point that they have filled up the post in the year 2015 without cancelling our appointment. They have cancelled our appointments in the year 2022 and they have filled up the post in the year 2015.
That,
That was the issue.
okay. The matter was listed today for delivery of orders. However, the Learning Council for the petitioners, for the parties has made further submissions in the matter. The submissions made by the Learning Council for the parties have been noted. So, registry to list this matter again on 23/7/2024 for delivery of orders.
Deeply obliged, Lordship.
Mr. Bhattakur, I have dictated the order, only the last portion is left. Just doing it, but I'm going against it.
Lords, but only one aspect, your lordship, I want to point out, your lordship. They have submitted that my promotion is a fresh appointment, your lordship. That, your lordship, in the affidavit itself, they have said it to be a promotion, your lord.
Promotion, but that promotion was effected in APGCM.
Lordship, that is there. Your
And you were redesignated. That's the, because what I have said is, because Brojan Soikia and this one, how to now harmonize both.
Lords.
Brojan Soikia was also promoted as assistant engineer in your APGCM.
APGCM.
So that stage onwards, what has happened earlier. From that stage onwards, you are an employee of APGCM. And you had come here on transfer.
Lords.
On your own request.
Lords.
So that roots, that earlier confirmation goes, because now there is a fresh probation here.
Lords.
That much only, that's the only reason I went against
Lord,
it.
I leave it. Deeply obliged.
Mr. Monto has come. Yes, Mr. Monto, you are the troublemaker now. Now we have two lists.
Right, ma'am.
Page 25
Yes.
and page 1, and the list given by Mr. Kaushik. Just have that list. Now both are in variance.
Yes, yes.
Then you have not denied this list.
I have not filed my affidavit.
No, that's it. We'll hold that you have not denied this.
My lord, give me some time, I'll take instructions.
Because this matter is of 23. You are here. You have not denied this. So if this is not denied, you are now projecting yourself as an English teacher.
My lord.
The petitioner is the social science teacher. So you will get it. Petitioner also must get it, because that's a declared subject.
Right.
Now you have converted that yourself to social studies and mathematics and reverted the petitioner, Joymoti, Assamese.
My lord.
Whereas in the dice data, she was appointed initially for social studies.
Social studies. Yes. My lord, with regard to the variation in the list, my lord, let me take instructions on that. And in any case, my lord, if I may humbly submit, my lord, since I'm the headmaster and I teach all subjects, and I'm the senior most in the school, my lord.
No,
once
you have projected yourself as English.
Yes.
Then why this other document you are shown as under your same signature? Both the documents have gone.
My lord, I don't think it is, my lord, my signature. Let me take instruction. It must have been fabricated, my lord. I cannot be too.
In terms of the directions passed by this court, by the earlier orders, Mr. P. Kaushik, Learned Standing Council, Secondary Education Department has placed on record the list purportedly furnished by the headmaster of the school, that is the respondent number 6 herein. So, on a perusal of the said list, it is seen that the respondent number 6 has projected himself in the said list to be teaching social science and arts, while the petitioner has been projected to be teaching Assamese. So, however, in a list annexed to the writ petition issued, shown to have been issued by the respondent number 6 himself, the respondent number 6 had projected himself therein to be teaching the English subject, while the petitioner was projected to be teaching the social science subject. So, the petitioner in the writ petition has also brought on record UDIs for the UDIs for the year 2019-20, wherein the The respondent number 6 is shown to have been teaching all subjects and also the language subject, while the petitioner was shown to have been appointed for teaching the subject of social studies as well as the language of as well as the language subject as the main subject number 2. Also, in view of the said discrepancy arising in the matter, Mr. P. Mohanto, Learned Counsel for the respondent number 6, prays that he be granted a week's 10 days time
10 days time.
to file an affidavit clarifying the above position, or affidavit on behalf of the respondent number 6, clarifying the above position. Also, prayer accepted. Registry to list this matter again on 27/7/2026. Also, the affidavit by the respondent number 6 be filed on or before 24/7/2026 without fail. Registry to list this matter for further hearing.
There's a recent judgment on the same issue, my lord, authored by Justice Majumdar, my lord. My lord has considered a number of judgments and that may be kept on record. I'll place it, my lord, on the next date.
Mr. Das, you had a
He was appearing. Profullo Kolitable. Abhi kole senior most hole di bolega. Social.
Yes, ma'am. It is, my lord, regarding seniority, my lord. Water language teacher, petitioner was senior, my lord. And the being junior, private respondent's appointment was set, sir.
Did listen.
Abul Hassan, is it my judgment?
Yes, yes, I think so. Yes, yes.
It went up to the division bench also.
Division bench कुछ नहीं. Deeply like them.
Yes.
May please, Your Lordship.
Hmm.
Petitioner here is challenge the disciplinary proceeding under Army Rule 26 were conducted illegally without giving him fair opportunity of defending, Your Lordship, which leads to illegal punishment, raiding entry, denial of service extension, and
You are challenging a discharge order.
discharge order.
That is Annexus 6.
That's it.
So you had completed your normal service
I have
tenure.
completed, I have worked for 24 years, 6 months, Your Lordship. And
This discharge is with pension.
Your Lordship,
So you are not given an extension.
I have not been given it.
Let us come to your
At
prayer.
least I may be given pension, Your Lordship.
You are not given pension.
No, Your Lordship. I was released from service on 1/5/2025, Your Lordship.
1/5/2015.
15, sorry, Your Lordship.
Okay, take me to the facts.
Lordship. Lordship, while petitioner was in field hospital in 12, he was served with a tentative charge sheet, Your Lordship. On 1/8/2014. Lordship may find it at page
23.
23. The charges are, Your Lordship, disobedient, may read the charge, Your Lordship. In that he, while performing his duty of admin so and so, dated 31 July 2024, referred so and so.
You are a Havildar clerk.
Havildar clerk, who had tasked him to prepare a report and return. Use of unsubstantive language. In that further, the above incident to be whole, Gupta, he was asked
These
to
are the
prepare a
charges.
report, but yes, Your Lordship, this is the charge. नहीं बनाऊंगा, तुम नहीं बोल सकते हो मुझे रिपोर्ट बनाने के लिए. He used such words, Your Lordship. He also further threatened him to mar dunga.
So you were directed to be thereafter tried summarily.
That's it.
Then what happened?
Thereafter, Your Lordship, based on this charge sheet, Your Lordship, proceeding was initiated under Army Rule 22, Your Lordship.
Army Act. Army Act 22.
22, Your Lordship.
Person seizure.
In that proceeding, Your Lordship, he was never allowed to
That proceeding was not taken to its logic. Although a penalty was issued, that was not taken to its logical conclusion
Lordship.
because some error was there.
Lordship.
Page 29 was issued thereafter.
Thereafter, please.
Same thing, but with modification of charges.
Lordship.
Now the proceeding was again held. Right?
Yes, Lordship.
Then what happened?
Lordship, disciplinary proceedings under Army Rule were conducted in complete violation of principle of natural justice, Your Lordship. Because, Your Lordship, he was never been allowed to examine the.
You declined. Okay.
Yes,
Where
yes.
have you filed an appeal or something against this? Page 36. Where have you taken that plea? So if we interfere with the penalty,
That's it.
your red mark will go.
That's it.
So you will not have 5 red marks, you will not have 1 red mark during the last 5 years or 3 years or something. Then this extension can be made for 2 years or 3 years.
That's it.
Was this appeal disposed of?
This appeal.
Appeal আছে জানো?
That was rejected in also. Yes, Ms. Gain, what do you say?
My lord,
He had taken this pleas in the appeal
yes, my lord.
that he was not given an opportunity to cross-examine.
Yes.
He had never declared, he had
guilty.
never admitted to the charges.
Yes, my lord.
But you have, the CEO has recorded in his own tone. Where are the materials to
My lord,
justify?
In this regard, my lord, kindly page number 47, my lord. Yes, and this is the proceeding, my lord. Kindly see, my lord, from paragraph number 1, the charge against the accused has been read out and explained to him and attached as annexure 1. Calling and hearing the witness in terms of Army Rule so-and-so has been dispensed with since the provision of AR 180 have been complied with at the court of inquiry in respect of the accused. Number 3, hearing of the charge commented on the comments on so-and-so date. The following prosecution witness were heard by me in presence of the accused who was given full liberty to cross-examine each of them. My lord, they declined, he declined, my lord, in that column 1, 2, 3, 4, my lord. Then, my lord, the accused was informed by me that he was at a liberty to make any statement at a call any witness in defense. A brief of the statement made by the accused is attached as annexure to this form. The accused declined to make a statement, my lord.
No, which one is correct? Accused declined or he made a statement?
No, my lord, declare, my lord. Here, the accused
Or.
yes, my
This
lord.
is the format you
This
use.
is the format, yes, my lord.
Which one did he follow?
My lord, as per our statement, my lord. Column 5. Paragraph number 6.
आमचा आमचा खूप पिला होता असं.
Yes. Here in our statement, my lord, in page number 6 of my affidavit in opposition, my lord, there is a statement in paragraph 12, my lord.
Where is the penalty imposed upon him? Where is the order?
Penalty. It's number Case number 28, my lord.
No, that is gone.
Yes, my lord.
That cannot wholly fill because subsequently, okay. No. Then 1/8, the fresh charge sheet was issued, tentative charges.
Yes. And no.
Page 31 is the discharge.
31
Certain discharge.
Penalty, your lordship may find it page 30.
30. Yes,
30.
penalty absent.
Yes, my lord.
But you are not aggrieved by the penalty, but the consequential effect of the imposition of that.
That's it.
This was your first red entry.
No.
Lordship.
Yeah,
Yes,
then
sir.
what was it? July 2000. Sorry. My lord, first resident is to page number 26, my lord.
No, that is gone.
Summary trial, yes, my lord.
That is gone.
Yes, my lord.
Subsequently, page 30 came.
Yes, my lord. 30, yes, my lord. That is first reading. And he pleaded guilty, my lord, in the reading, in this procedure, my lord.
Where?
My lord, kindly see column 1 to 3, my lord. Of that page number 30, my lord.
Guilty, guilty, guilty.
Yes, my lord.
Where is his signature here?
Signature, my lord, Major Samandi. Is not there, my lord.
So where is this record of proceeding under Army Rule 22 in pursuance to the second tentative charge sheet?
Second, my lord. That is one.
Okay.
6.
So this is 5/8, page 24. This is after the page 29.
Page 24 is after page number 20.
29. What was the
Yes,
year?
page number 29 is of 1st of August 2014 and page number 24 is of 3rd of August 2014, my lord. That is after the page number 29, my
No,
lord.
the
Yes.
earlier one is also,
Five August.
earlier one is also same.
5 August 2014.
Where is the records?
Record is no, we have
Get the
to,
records.
yes, madam.
Heard the learned counsel for the parties at some length. This court on consideration of the submissions made by the learned counsel for the
Then-
parties is of the view that the original records of the proceedings instituted against the petitioner is required to be perused. So Ms. Agan submits that she will produce the original records in original on when?
My lord, posting is, what is the posting?
He is not there now.
He is not there, but field hospital,
Field Hospital, 2012.
2006 field hospital, care of 56 APO.
my
This
lord,
is 99.
99,
Field hospital.
56, this is 1956 APO, my lord.
Somewhere outside.
Yes, my lord, outside, because it is 99 APU, my lord. উঠি লোৱা আছে। কিমান দিন লাগিব? নাম্বাৰটো লোৱা আছে নেকি? 56 is, my lord, some time may be given to record, my lord.
Registry to submits that she will produce the record or the records in original on. Give me a date.
My lord. This second week of August, my lord, because it comes from outside an old mail.
On 6, 8, no, second week.
11, 12, any date, my lord.
Let us have it in the third week.
Yes, my lord.
On 17/8/2025. Huh?
Yeah.
So accordingly, registry to list this matter on 17/8/2025 for further hearing.
Master blessed.
Oblige, Your Lordship.
হৈ গ'ল? এই যে আধা হৈ আছে নহয় কেইটামান।
নিজে পঢ়ি ক'ব লাগিব।
এই আগৰ কেছটোত সোমাই থব লাগে। বচি কৰিছো থৈছো। শান্তি। এইখিনি দি দিম।